How to answer a debt defense lawsuit in Texas. Hi, this is consumer protection attorney Bill Clanton. I've helped hundreds of consumers deal with debt collection harassment, inaccurate credit reporting, and other consumer-related matters. In this video, I'm going to tell you how to answer a lawsuit, a debt defense lawsuit in the state of Texas. Okay, it's important to get an answer on file because if you don't get an answer on file, the other side will get a default judgment against you. And they can use that default judgment to garnish your bank accounts, get a receiver appointed, freeze bank accounts, get your credit report, do other things to collect money from you without you having much defense to it. So the best time to defend yourself is after you've been sued, and the best and easiest way to accomplish that is to file an answer. This will give you time. This will give you the opportunity to do discovery, give you time to negotiate. It'll put a hold on them getting a default judgment. It doesn't mean they can't get a judgment against you, but it will slow that process down tremendously. Okay, and allow you to defend yourself. So what do you do when you file an answer? All right, this is the basic form of an answer here. You have a cause number or case number that goes on top, and that is required to be in your answer. You have a plaintiff, and you are the defendant. You or someone you know is a defendant. Okay. You separate these two columns. Then you have the court system up here. A lot of these cases, hundreds of thousands of them every year in the state of Texas, are filed in the JP court system or the justice court system. So you could say the precinct court. Precinct number 1, 2, 3, 4, 5, whatever precinct this is filed in, you put the precinct number. And you put in your county, Texas. All right, and then the title of the document is here, the defendant's original answer. If this is a second answer, if you already filed one, you can call it the first amended or second amended, or make sure that's accurate. But for most folks, it's going to be defendant's original answer. All right, and here's what you need to say to answer a lawsuit. Defendant generally denies plaintiff's allegations. That's it. Texas allows for a general denial. You do not have to do a specific denial or anything else. A general denial is sufficient. Now, if this is a suit on a sworn account, it used to be a popular tactic years ago. I don't see it so often now. If this is a suit on a sworn account, this could be different. You may need to verify your denial, make it what they call a verified denial. But for most cases, a general denial is all that you need. You don't need to list the paragraphs and deny the allegations in each paragraph. General denial will do it. Now, it's important that you put your information in this document. You need to sign it. You need to put your name, you need to put your address, your phone number, and your email. This is important because the court and the other side need to know how to get a hold of you, to give you notice of hearings or to send you documents, things like that. So that's important to put in there. And that is, in fact, one of the things that's required in an answer. Now, you also have to certify that you served this on the other side. So how do you do that? A certificate of service. You say, I certify that I served this document on the following by, you can say certified mail, email, regular mail. Now, JP Court, where most of these suits are filed, has some special rules. If the other side consents to service by email, you can serve it by email. If you read their lawsuit carefully, it may say they consent to service by email. And if they don't, then you have to send it certified mail. So send it certified mail, and then the date you sent it by certified mail. And then you need to say who you sent it to. So put their lawyer's information. Their lawyer's name, address, phone number, and email goes down here. And then sign it. And then put this in the mail. However you told them you were going to send it in the certificate of service, send it that way, whether it's by email or by certified mail or by regular mail. Get it to the other side. And then you will have answered the lawsuit. Oh, you don't have to, in addition to sending it to the other side, you have to file this with the court. You can mail it to the court or you can walk it to the court. If you walk it to the court, take an extra copy so you can get your copy file stamped. That file stamped copy will be your proof that you filed this with the court. Debt collectors deal with hundreds of thousands of cases every year. And unless you have a file stamped copy, you may not be able to prove that you filed it, or you may have to go back to the court to get the proof that you filed it. So go ahead and get one now, because if they try to file a default judgment after you filed an answer, then they've violated the law, and you can file a counterclaim for that. So this is how to answer a lawsuit, a debt defense lawsuit in Texas. If you have any questions, give us a call. We're happy to answer your questions. And if you don't want to handle this yourself, give us a call. We can talk to you about handling it for you. Thanks for watching this video. I hope you've learned something and are better prepared than you were before you watched this video. If that's the case, I'd appreciate you subscribing to this channel, and thanks again for watching.